Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about sexual assault. Cases that should have gone to the Supreme Court of Canada, but didn't. Deng Achu was a person who was charged with sexual assault. At the trial, as is the case with many sexual assault trials, the complainant testified and said that the sexual act that took place between them was not consensual. Then, Mr. Achu testified and said that it was consensual, and the court had to wrestle with who to believe. This is a common thing that happens in the vast majority of trials in Canadian courts. He said, she said. The problem in this case was that the trial judge also considered whether Mr. Achu had an additional defense, that being that he had a mistaken belief that she had consented to the sexual act, even though she had said that she hadn't. And this is potentially a defense if certain elements are made out. The problem that arose was that this wasn't a defense that was advanced by Mr. Achu. It was raised on its own by the trial judge. And Mr. Achu complained that because the trial judge raised a defense of her own accord without allowing him to lay the evidentiary foundation and argue it, he was effectively denied trial fairness, and also the judge reversed the burden of proof by manipulating his defense into something else. And this case emphasizes some of the really important tensions that we have in sexual assault cases in Canadian law, where there are differences between cases that merely turn on credibility, like Mr. Achu was saying, if you believe me, she consented. If you believe her, she didn't consent, versus cases where the waters are a little more muddy because human interaction, particularly in a heightened emotional situation where hormones are raging, can be confusing. And the problem is that with the different evidentiary standards for the various types of defenses and credibility arguments that apply in criminal cases, and the different aspects that an individual has to prove or disprove, or the Crown has to prove or disprove, blurring these lines can be a very big problem. The Supreme Court of Canada should have spoken up to emphasize the role that trial judges are supposed to play in gatekeeping defenses, in considering legitimate defenses as they arise, but also not into stepping into the role of conducting the defense and making decisions on the basis of defenses that clearly are not argued at trial. This was somewhere that the Supreme Court of Canada could have clarified some of our sexual assault laws and the ways that the different defenses tend to interact with each other, making those lines between the defenses and the credibility contests more clear so that trial judges don't commit errors or improperly fail to consider defenses in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.